So without further ado, let's get going. Okay, so the fundamental question is, what is software as a service? So software as a service is essentially a business model where a software application is delivered to a customer, or sometimes referred to as the end user, usually as a service over the internet. So the end user does not purchase a copy of the software and access it on a essentially a time sharing basis via subscription. So another way of saying it is, in essence, the end user or customer is just renting the software on an as needed basis. Okay, so the flip side, what is not SaaS, right? And SaaS is quite simply, it's not generally a software license or an assignment. And if you get these concepts clear in your head now, these are very important concepts from an IP perspective also. So SaaS is typically, not from a legal perspective at least, a software license, right? So what is a software license? And I've worked in Dell for many years, and it used to baffle me and confuse me that there's thousands of people selling software in high positions that they really still don't understand what they're selling. They think they're giving away the full suite of IP rights. So a software license can be thought of as the permission of the owner of the property to use that property. So a software license is simply the permission from the software owner, who we can refer to as the copyright owner, to use the software. So in this situation, the owner is not giving away all of the rights. He or she is only giving away a small part of the bundle of rights that make up complete legal ownership surrounding copyright. So many moons ago, when I was studying in UCC, my law lecturers would have given examples of, like, full legal ownership is like a big bundle of sticks, right? And when you give somebody a license, right, you retain most of the sticks. You only give them some of them. Okay, so that's kind of an easier way to kind of get your head around. So this then can be referred to, what is referred to as an assignment. And you'll all be familiar with this expression, the company has assigned its rights. And this is essentially where, instead of giving just some of the sticks, you're giving away all of the sticks. You're like, why is this guy talking about sticks? But anyway, so an assignment to the copyright essentially means that the copyright holder, the assignor, is transferring all of its rights to another party, usually the assignee, in return for a fee or perhaps some form of royalty payment. So this is what you really do not want to do. And if you just want to license the software, because essentially you're giving away the complete bundle of rights, as you'll no longer be left with any proprietary rights in the software. So therefore, care must be taken when drafting what's referred to as the license grant, to exclude such an eventuality. And if you look at the license grant section in all of the major vendors' kind of off-the-shelf software, like Microsoft or Oracle, and in their end user license agreements, you'll see like that they go to great lengths and care to say that, look, this is a license we're giving you, right? It's granting you, and it should not be considered to be an assignment of their rights. So, and also, in fact, it's common practice to also exclude the possibility of the licensee assigning his rights also. Cool. Can I just check that everybody can hear me okay?
All good for me anyway.
Perfect. Sometimes it's strange when you're just kind of talking at the screen, and we'll have some questions at the end, so don't worry about that. So look, to recap, right, we cast our minds back then to what is SaaS. So SaaS, there is no license grant or assignment, since all you're really selling is access to the platform or service that runs the particular software, right? The license, software license, is a limited form of legal ownership in the software, subject to kind of terms and conditions. And these terms and conditions are many and varied. But essentially, with the standard licensing model, the customer typically takes the license and installs it on premise so that they have access to it on their systems, right? And if you think about assignment is transferring all of your legal interest in the software or IP in totality. So get those concepts clear in your head, and they'll stand you in good stead in conversations when these things come up. Okay. So some of the advantages of SaaS. So typically, SaaS allows the software vendor to reduce its support costs by maintaining a single version of its software on a single platform, and in turn, then customers will benefit from this reduction in the support costs. Customers typically benefit from having updates automatically made available to the software, and they do not need to pay for the newest update. Now, this is generally speaking, and it is possible to include contractual language to the effect that the customer will need to pay more for additional features or updates, and that can be done, and I've seen it being done. But in my opinion, at least, I think this is the most beneficial aspect of SaaS, the SaaS model, right? And is that it allows the software vendors to sell to customers who may have otherwise not been in a position to purchase such software because A, they didn't have the infrastructure to support it, or B, they simply didn't have the budget for it, right? And so essentially then it's going to make really good software available and more affordable to a broader portfolio of customers. The disadvantages of SaaS, and look, I'm sure a lot of you have had these conversations with your prospective customers and have had to handle these objections in your own way, but it's definitely worth thinking about these issues and how you will handle them when they come up with your customers, or at least prospective customers, I suppose is more accurate. So the greatest basis of concern from the customer's perspective is that it has relinquished control of its IT to a third party. Think about all the big financial houses out there. Will they be very comfortable, all their data going to be stored off premise, a third party having ultimate control about it? It's a system that they that it's going to be very difficult for them to replicate if they need to. So certain challenges can definitely arise where the software vendor ceases trading, as it can prove very difficult then for the customer to replace the service. So in a typical on-premises perpetual licensing situation, the end users will have access to the source codes through what is called an escrow arrangement. And essentially these software escrow arrangements, they have what they call trigger events in them. And some of these trigger events are kind of like, a material breach of the contract by the vendor. The vendor takes steps to cease trading, like maybe a receiver is appointed or a liquidator is appointed to the company. And essentially in those scenarios, the customer can gain control of the source code. And in my opinion, they should be able to gain control of detailed manuals around how to develop the software again. And so this kind of protects the customer in the on-premise perpetual licensing situation. Now, the problem with SaaS is, right, it's very difficult to replicate the system again. And escrow arrangements are they're starting to become popular for SaaS now as well. But traditionally, they were kind of shied away from because people thought, look, they're actually not worth the paper they're written on. But there are companies out there now that will provide these type of escrow arrangements around SaaS. And if you do come across this issue with, say, particularly big customers, there's a solution there. But ultimately, though, and the customers will know this, it's very difficult to replicate the SaaS environment and have confidence that they can do it, I suppose, quickly and effectively. The other consideration for a customer is that most software vendors will not customize the application for specific customer needs, and this can be an issue and a deterrent to some customers, wishing to avail of the SaaS model. And again, that's just a general statement. Of course, things can be customized, but more established SaaS businesses, they may not want to do that. Okay, security and SaaS. Security, as you're aware, it's always a very important concern when utilizing a SaaS model. However, it's probably worth stating that by centralizing the data in a secure data center, the customer may actually be increasing its security. So that's a kind of an objection you could have to that query. On the other hand, the client has given over all of its control of its data and is now dependent on the vendor for protection. So typically, prudent customers will address these concerns, and incorporate the appropriate security measures in the underlying agreement. And I have seen scenarios where customers will actually want to visit where the data is being stored, visit the vendor's premises to see that there's appropriate security measures in place, and so forth. GDPR and SaaS. GDPR is an issue that comes up in most commercial contracts, but given the prevalence and the nature of SaaS, it definitely needs to be accounted for. So particularly for your European customers, right? Because European customers, they'll require that all of their data remain within the EU, essentially to avoid subjecting the customer to the laws of other jurisdictions in which the data resides, and in particular, most likely breaching the GDPR without having taken the proper safeguards and implemented additional contractual protections. So what should the contract say? The contract, it should address the parties' respective responsibilities for complying with all GDPR requirements, and include what are referred to as controller and processor contractual provisions. It should also include provisions around the notification of data breaches. The vendor should also be obligated to notify the client immediately in the event of a data breach, and provide a detailed written explanation of the nature of such a breach and the actions it has taken to remedy the breach. Okay, disaster recovery. The software vendors' disaster recovery will be carefully reviewed by larger clients. Performance standards and SLAs. So this is a frequently heavily negotiated section of a SaaS agreement, to be fair. So when entering into a SaaS agreement, the customer will seek to include what are referred to as performance standards, to ensure that the promised services meet the particular customer's needs and expectations, right? So what are those common measurements, like availability, response time, and scalability? Perhaps the most important metric from the customer's perspective is around planned outages. So many customers will insist on something like the availability of 99.99% per month, and that all maintenance will be scheduled in advance and limited, between the hours of 12 a.m. and 4 a.m. on weekdays and on weekends. So from the customer's perspective, the availability of any service credits, they should be carefully delineated in the agreement. The agreement should include examples of how such service credits are calculated and applied if a service interruption occurs. So just a bit of a side note on this topic. When you're talking about service credits, the issue of penalty clauses frequently comes up, right? So clauses that seek to impose a penalty are notoriously difficult to enforce in most common law jurisdictions, unless the clauses have been carefully considered and are what is referred to in the case law as genuine pre-estimations of loss. So I think actually there's an article on my website about penalty clauses if you want to find out more about them. But this is really an issue on the customer side, but I'm flagging it because don't be surprised if the lawyers on the customer side insist on including some sort of a formula in the contract setting exactly what their loss is if the performance standards are not met. And really what they're trying to do is to make sure that clause is enforceable from a legal perspective and bring it outside the definition or the ambit of what is considered a penalty clause. Okay, contractual protections. So most software vendors, they seek to have the client sign a pro forma, a click-through contract, and we're all familiar with these contracts. And they do so it's without amendment and with essentially very little contractual protections provided. So typically these contracts disclaim almost all the vendor's warranties and liabilities, and they limit the liability to essentially a multiple of the monthly fees paid or the annual fees paid, as the case may be. So the position of the software vendor, why they use these kind of pro forma contracts, is because it's industry standard and they're in line with the low cost they are charging the customers. So from the customer's perspective, they should carefully evaluate these contracts, and particularly the pricing model, to ensure that the pricing structure is clearly delineated and that the client essentially has the ability to independently verify any amount that is billed by the vendor. So in terms of the warranties that the vendor will give, right, it's usually very, very tight on the kind of more run rate stuff, and it's usually just one warranty given, that there will be no material reduction in functionality at the time of the license or service agreement. On flipping back over to what responsibilities the customer owes the vendor. So the vendor, particularly where customers are putting data into a system, right? They will require what is referred to as an indemnity, right? That the vendor will be indemnified against any third-party claims concerning data placed in the cloud by the customer that infringes a third party's intellectual property rights. So in addition, the customer shall indemnify the vendor in the event that the customer breaches the terms of the service agreement, as well as in the event of its failure to follow the contractually required security procedures. So I probably should backtrack a little bit here. I touched on warranties and indemnities. Like you really don't want to be given indemnities, but you want to be kind of getting them, right? So like a warranty really is just like, I warrant that this is a set of circumstances at this moment in time. An indemnity is like, I will give you X amount, or I will completely indemnify you if X happens. So indemnities from a legal perspective are pretty vicious, right? Because like, if you go in front of a judge with an indemnity, like, it's like, the other party doesn't even need to be there. It's like enforcing a debt. So I always counsel my clients, be very careful what indemnities in particular you are giving. Okay. Okay. So pricing. So this is a like, it's probably worth a whole talk in and of itself. And I do say at the very beginning of this, like, that I'm not an expert on software pricing. Software pricing is an art form in itself. And when I worked in Dell, there was huge function within Dell called the deal desk team, and they would be, their sole purpose was to structure the pricing correctly, and to basically guard against, the kind of unfettered discounting practices that the sales teams love to kind of be involved in. So typically through a SaaS model, customers are charged through a variety of means, including, on a per user basis, on a per month basis, on an enterprise basis, or perhaps based on the actual usage of the software. So again, the advantages in this regard are that the true cost of the software to the software vendor are spread out over the lifespan of the customer relationship, right? Rather than being recovered in one large sum at the outset, which is typical in a standard software licensing arrangement. So this cost spreading is then passed to the customer in the form of a kind of an affordable monthly subscription. Okay, so here's a quote. Actually, I think it's a really good quote, and this thing called price is really, really important. And Steve Ballmer, the ex-CEO of Microsoft. So like, if the head of one of the biggest software companies in the world is saying something like this about pricing, like, it does make you ask the question, how much more does a small software company really need to think deeply about its pricing? This is something that I'm passionate about when people come to me with their software contracts, and it's like, Dean, structure the contract, get it done. Let's really think about the indemnities and the warranty. I'm like, what about the price? Have you thought about your price? Right? And 9 times out of 10, people haven't thought about the price. Okay, so you can think about SaaS pricing from kind of 2 perspectives in my experience. Okay, so you kind of have the macro and the micro. On a macro level, right, most founders that I talk to, like, they often price their products because they feel that a particular price is the right price to charge, or because they feel that potential customers won't pay more than, X euros, right? On the micro level, the founders often feel that a particular prospect or deal won't do the deal unless they get a particular discount off the price, or they provide some other concession, right? Such as more support, free or underpriced professional services, or simply, they just roll over and you agree to bad licensing terms that are not in your favor whatsoever, or bad contractual structures. So reacting like this in the early stages will have a major knock-on effect down the line. Okay, so what young SaaS companies should do / consider in terms of their pricing. So again, keeping the macro and the micro kind of thing going here. On the macro level, right? So you need to create a pricing strategy. So like, are you pricing for market share or profitability? Like, what segment of the market do you want to target? Like, what vertical, customer size? Like, how are you going to license the product? Is it going to be on a per seat, a per user, a per enterprise? The list goes on and on. Do you want to sell or implement through partners, right? Can you OEM the product? Can you OEM other products? Like, what impact scenarios would trigger a pricing review? Think about all of this and document it, and so that you've thought it through for when the time comes. Sounds obvious, right? But create a price list, right? Should that be stored just internally? Or are you going to make it externally available? There's pros and cons to each one. Create the right contract structures to support that pricing strategy. So there's no point in having a great pricing strategy and great licensing definitions if the contract doesn't all marry up to that vision, set the right price points for your product. So define, and I think this is probably the most important point here, right? It's like, define what provides customers with the most value, right? And then monetize that value accurately. So you need to analyze, right, what impact am I making on my customer's life? And how do I put a figure on that? And there's people out there that do this for a living, and then you need to monetize that value accurately and stick to that proposition. Okay, so on the micro level, right? So you need to define the process, the price a deal. So the key is to avoid like the last minute pricing decisions made under pressure to close a deal. When I worked in Dell, like, there was a very, very structured way that a deal was priced. Create a set of rules around what gets discounted and under what circumstances. Like, this is referred to as an approval matrix, right? And who makes the decision to discount, and why, and subject to what parameters. Think these things through. Like, are you going to give away, like, lots of free support in return for getting a particular logo? Like, you need to have thought about it. So look, pricing correctly is also is a key consideration for both emerging and established SaaS businesses, in my opinion, right? It all starts with setting your value proposition correctly and monetizing that value correctly in a way that builds trust and connection with your customers. So in turn, the value needs to be represented by using the appropriate licensing metrics and contractual structures. You get this mix of issues wrong, and you might win a customer for a high price point in year one, but the chances are that you will lose it in year 2 or 3. And this is sometimes referred to as the difference between bad growth and good growth, right? So as I said, pricing software is an art form in and of itself. And for that reason, I've actually partnered with a consultant, right? And he has set up and run many commercial deal desk functions for large commercial software houses. And if you feel that you could benefit having him guide you a little bit, let me know and I can make the introductions. Lastly, I just wanted to touch a little bit on, valuations and pricing. And this kind of is really where the rubber meets the road sometimes for people, right? So my price point, what does it mean in terms of the valuation of my company? And there's many aspects and many things that go into valuing a company, and we're not going to get into the detail of that today, but like in terms of pricing, right? So it's like revenue, growth rate, the business vertical the software is targeted into, the gross margin, and the churn rate. These are all things that go into the mix of coming up with a number. So in terms of revenue and growth rate, these are definitely, in my opinion, the 2 key metrics. So let's say you have a growth rate of between 35% and 50%. You can probably expect a revenue multiple of around 9 or 10 for a solid SaaS business, right? Now, this means that you have what is referred to as a low churn rate, and that equals, like, say, a retention rate of 90%. But churn, right, it's difficult because there's kind of 2 understandings of churn. There's churn logo and there's revenue churn. So let's say, for example, you've 10 customers, right, and the revenue is $1 million, so 100K each. The following year, then you still have 10 customers, and it's at 900K now, the revenue. So your logo retention was 100%, but your revenue retention was at 90%. So you can see why, I suppose the key message is like, you need to set the price correctly and that maximizes your revenue potential and minimize churn as a SaaS business. So minimizing churn means like it's not just about selling a product to people that they really like and they want to use. It's also about the pricing strategy and the contract structure that will make the software as sticky as possible. Get that right, and you're well on the way to having a valuable company. Thank you.